Implementing the Code of Practice on the Prevention and Resolution of Bullying at Work. Welcome to this Fáilte Ireland video series designed to support tourism and hospitality businesses in meeting your employer obligations. My name is Dominica O'Sullivan. I'm a human resources consultant with Action HR Services. In this video guide, I will address the subject of the Code of Practice for employers and employees on the prevention and resolution of bullying at work. Within this topic, we will discuss the contents of the code and its implications on employer responsibilities in relation to proactively managing the workplace, as well as dealing with bullying complaints. We will consider a definition and examples of bullying, an overview of the Code of Practice and legislation, employer and employee responsibilities, the process for handling bullying complaints, risks associated with non-compliance, and we will finish by sharing some top tips. The Code of Practice for employers and employees on the prevention and resolution of bullying at work came into effect on the 23rd of December 2020, and from that date it replaced all previous relevant codes. The Code of Practice provides helpful guidance for employers and employees on identifying and preventing bullying at work. The Code defines bullying and provides specific examples of what can and should not be classified as bullying behaviour. According to the Code, bullying is repeated inappropriate behaviour, direct or indirect, whether verbal, physical, or otherwise, conducted by one or more persons against another or others at a place of work or in the course of employment, which could be reasonably regarded as undermining the individual's right to dignity at work. The Code provides an extensive list of behaviours that may constitute bullying. Let's look at some of them now. Exclusion of an employee with negative consequences or purposefully excluding him or her from team events, verbal abuse or insults, name-calling and the use of obscene language when addressing an employee, regularly treating a certain employee less favourably than others within the team, belittling a person's opinion, spreading malicious rumours or gossip, intrusion, pestering, spying, stalking or monitoring an employee excessively, intimidation or aggressive interactions, purposefully not sharing work-related information an employee may need to carry out work duties, repeatedly manipulating an employee's job, content and targets, blaming an employee for things that are beyond their control. In addition, the Code makes a distinction regarding behaviours that some could perceive as bullying, but are not actually bullying. For instance, expressing differences of opinion strongly, offering constructive feedback, guidance or advice about work-related behaviour which is not itself welcome, ordinary performance management, reasonable corrective action taken by an employer or supervisor relating to the management and direction of employees, for example, managing a worker's performance, taking reasonable disciplinary actions or assigning work, work-based conflict where people disagree or disregard the other's point of view, a once-off incident of bullying-like behaviour. This code applies to all employees in Ireland, irrespective of the type of contract they are employed under and irrespective of the work location or, for instance, a fixed location, working from home, or in a hybrid manner. It also makes a reference to instances where bullying may occur online. The code further outlines that an employee may be subject to bullying by somebody directly employed by the organization, a customer or business contact, for instance, a supplier or a contractor. The code also acknowledges that the devastating effects of bullying on a personal level, specifically the decrease in performance and productivity at work, as well as persons' mental well-being, and at an organization level, a dysfunctional work environment, low morale, lost time, and potential litigation issues. While the basis of this video guide is informed by the Industrial Relations Act, Code of Practice for Employers and Employees on the Prevention and Resolution of Bullying at Work order, it is also important to consider other relevant legislation, specifically the Safety, Health and Welfare at Work Act, Common Law, Unfair Dismissals Act, Industrial Relations Act. Other videos in this suite address employer responsibilities under Safety, Health and Welfare at Work Act, and specifically the duty to ensure the health, safety, and welfare of all employees as far as reasonably practicable, which includes providing a workplace that is free from bullying. This is closely linked to the common law duty of care obligation by employers to provide a safe place to work. In addition, the principle of vicarious liability means that employers are liable for their employees' acts or omissions that occur during the course of employment, for instance, one employee engaging in a bullying behavior towards another employee. Additionally, the unfair dismissals legislation describes a scenario whereby an employee terminates the contract of employment due to the conduct of the employer, for instance, where the employee was subjected to bullying in the workplace. This scenario is commonly referred to as constructive dismissal. In addition, employees can also seek redress under the Industrial Relations Act while they're still employed should they be dissatisfied with how their complaint was dealt with or if their complaint was ignored. So let's look at what employers and employees should do in the workplace to prevent bullying and deal with bullying complaints. The code focuses in detail on proactive measures employers should implement in the workplace with a view to preventing bullying behavior while creating a culture of dignity and respect at work. There are several elements important to a positive work culture, including good leadership, leading by example, a culture of involvement and a proper flow of communication, intolerance of inappropriate behavior and training of all employees on acceptable conduct. Therefore, management within the organization should lead by example by treating everybody around them with respect, promoting good manners and common courtesy, creating a positive atmosphere in the workplace by rewarding positive behaviors and good teamwork, as well as dealing with conflict effectively. This means that at the first sign of conflict, the manager should intervene. For example, when they observed an employee making inappropriate remarks or making jokes about another employee, he or she should speak to the employee in question in private and advise them that their behavior is not appropriate and will not be accepted. In response, some employees may say that they did not realize that what they were doing was inappropriate or say that their behavior was meant as a joke. In this instance, the manager should clarify that the behavior is not appropriate and should stop. The manager should also remind all employees involved about the anti-bullying policy and finally check in with the affected employee to advise them that the issue was addressed, but should there be any repetition of the inappropriate behavior, the manager will intervene again, and employee affected has an option to evoke the anti-bullying policy at all times. In addition, being proactive means that managers should ensure the psychological safety for employees so that all employees feel that it is safe to come to the owner or manager to report incidents of alleged bullying. In a case where a manager is approached by an employee who believes that they are subject to bullying behavior, the manager should thank the employee for raising the issues and assure the employee that they will be supported in reaching a resolution. The manager should refrain from commenting on the validity of allegations raised and instead advise the employee of the resolutions options available under the organization's policy and remind the employee about the employee assistance program if it's available. In relation to other proactive measure, the code also requires employers to carry out a risk assessment and identify what can be done to minimize or eliminate bullying at work. Employers should also ensure preventive measures identified are included in the organization's safety statement. In this video, we are also addressing all such proactive measures, which should be considered when conducting the risk assessment and included in the safety statement. We also provide a template for a risk assessment in the resources accompanying this video. Let's discuss the requirements for establishing a policy next. The code emphasizes the importance of creating a robust anti-bullying policy and procedures that voice the organization's commitment to ensuring the culture of dignity and respect and recommends that those policies and procedures are drafted following consultation with, for instance, a union, employee representative, safety representative, or a safety committee. Appendix 1 of the code provides detailed guidance information as to what exactly should be included in the policy and procedures document and how to proceed with implementation. This offers a great template and guidance for employers in developing and implementing the policy. In relation to other preventive measures, the code highlights the necessity of making all employees fully aware of what is in the policy and of providing appropriate training for employees and managers. For any such communication and training to be effective, the employees should be given specific examples of unacceptable behaviors. Additionally, the employers may utilize role plays during training sessions to teach employees how to professionally and effectively approach an employee that behaves inappropriately towards them, and what options are available to them should they have a bullying complaint. All employees should also be advised that it is their responsibility to report any behavior that may be considered bullying to the manager. Due to the serious nature of bullying allegations, the employees should also be advised to ask themselves the following questions. Have I read the policy and am I clear on its contents? Is the behavior upsetting me due to other than personal reasons? When I'm being given feedback by my manager, is it constructive and warranted, and does it focus on me improving my performance? Is it a personality clash, and is there anything I'm doing to contribute to the conflict? Is it a repeated pattern of behavior, and am I offended by it? Have I tried to address the behavior with the person in question, or do I need advice on how to do it? In regard to dealing with a potential bullying complaint, the code emphasizes that addressing the issue early offers the best possible potential for a good outcome. Apart from having devastating effects on physical and psychological well-being, bullying destroys workplace relationships and teams. Therefore, early resolution may help to protect the relationships from being broken beyond repair. If an employee or a manager witnesses inappropriate behavior, they have the responsibility to act, for employees to report it and for managers to step in. If the behavior is not witnessed by a third party and it's the employee that comes forward with the complaint, the bullying procedure should be offered to them with numerous resolution options. Firstly, the employee should be referred to the organization's anti-bullying policy and encouraged to seek advice from a nominated contact person to assist them to progress the complaint to ensure the appropriate resolution. The options available to them should include mediation, first informal stage, second informal stage, and a formal stage. You will find a complaint handling step-by-step guidance tool among the list of resources accompanying this video. Let's look at the various stages to addressing and seeking resolution to a bullying complaint now, starting with outlining who a contact person is, their role and responsibilities. A contact person is the go-to for any employee inquiring about dealing with a potential bullying complaint. A contact person, when approached, acts in a supportive capacity, listens, and offers guidance on options available to an employee, all on a strictly confidential basis. When acting in a contact person capacity, he or she may be asking the employee the following questions. Who is your complaint referring to? What happened and when did this occur? Have you made the person in question aware that the behavior is not welcome and unacceptable? Have you reviewed the company policies? What questions do you have on the policies and procedures? Bullying complaints need to satisfy the definitions. Have you reviewed the definition within the policy? Bullying is repeated inappropriate behavior. Does your complaint refer to a repeated issue? If not, let's discuss the grievance procedure. What resolution option would you like to take? Would you like me to talk you through the different options? Apart from discussing options, supporting employees who come forward and advising how to proceed, a contact person should have no further involvement in relation to the complaint. It is recommended that every organization appoints a contact person and chooses employees who are naturally approachable, empathetic, calm, objective, and good listeners. Every organization should publish the details of contact persons and how to get in touch with them. This information can be shared via intranet site, a handbook, or notice board. In line with the provisions of the code, the contact persons should receive their relevant dignity and respect at work training that will aid them in developing capability in this area and set them up for success. If an employee who has a complaint wishes to resolve it through mediation, he or she should inform the contact person, their line manager, or a member of the HR department if available. Mediation is an informal voluntary process where an impartial, competent, qualified mediator enables individuals to talk through and work through conflict or disagreement with a view to improving their relationship. It is not about blame, but about understanding the conflict and finding agreed ways of future interaction and behavior. Where mediation is availed of, the information that is shared by the involved parties remained confidential and cannot be used later, for instance, during the investigation. Finally, mediation does not deny the right to a full investigation at later stage. It should be noted that employers are not required to have qualified mediators employed within the business team. It may be most appropriate to choose to outsource this role and process to a third party. An employee who has a complaint can choose to resolve the complaint through the initial informal stage. To address the complaint through the informal process, the employee should speak with the person who is alleged to be engaged in the unwanted behavior. The reason for this is that sometimes the person may genuinely be unaware that the behavior being complained of is disrespectful or unwelcome or undermining, and that it is causing distress. If the complaint relates to the employee's direct manager, the employee should speak to another manager or the line manager of the manager in question. If the first stage of the informal process is unsuccessful, or if the employee who has a complaint or the employer deem it inappropriate due to the seriousness of the allegation, the secondary informal stage should be progressed, or a formal investigation should be considered. The second informal stage starts with the employer appointing a nominated person, separate from the contact person, who is suitably trained. This can be one of the managers within the organization. The complaint should be submitted to the nominated person either verbally or in writing. If it is submitted verbally, the nominated person should write down the details of it, including dates, specific incident, witnesses, etc., and he or she should give it to the employee who complained. Receiving specific details of the complaint is vital, as without these details, the right to response for the employee accused of bullying is likely to be compromised or hindered. Once all the details are captured, the person complained against should be presented with the complaint and the response established. This could take place during an informal meeting facilitated by a nominated person with both parties. The nominated person would allow the employee who has a complaint to outline it to the other party in a controlled and facilitated environment, allowing the other party to respond with a view to establishing agreement by both parties on how to move forward without the nominated person taking sides in any way. During such meeting, the nominated person will do the following. Explain to each person that both parties will have time to talk and both parties will have time to listen. Explain the purpose of this stage as being important to fully understand the issues and the impact of the behavior on the other person, not necessarily to seek agreement on them. When both finish their uninterrupted speaking time, summarize what they have said and ask them to clarify that they understand the issues. Encourage them to ask each other questions to seek clarification. If there is silence, it is recommended to prompt with a question like, "Is there anything you would like to say to each other?" Be actively involved in the conversation, but get them to do the talking. Questions or statements they could ask during the stage could include, "Is there anything you would like to add on how this has impacted you? Is there anything you want to add on what you need? Is there anything else you'd like to add?" You stated that you were wrong, Mary. What is your response, John, to what you just heard? Once they have spoken about the issues, wrap it up. Summarize the issues again. So, to summarize, there are 3 issues here as I see it. Do you agree? And ask, are we ready to move on? During the secondary informal stage, managers of the employees involved should be involved that the process is taking place with a view to ensuring no repetition of alleged conduct occurs. Finally, the nominated person should keep a nominal record of the complaint, the meetings, and agreed actions with signatures of both participants. Those records should be kept on both employees' files. It is noted that no other details of conversations should be kept. If the complaint is resolved at this stage, both parties should be provided with ongoing support. This can take a form of regular check-in meetings aimed at monitoring that no further issues are arising. However, the matter is unresolved, a formal stage is available next. It is important to note that no employee has the right to immediately proceed to a formal stage when making a complaint. However, this can be done if the secondary informal stage was unsuccessful. Escalating the complaint to the formal stage when the complaint is initially made should only be done following a review of the circumstances surrounding the complaint by an appointed manager to establish if the behaviour complained of meets the definition of bullying in principle. This would involve looking at the written complaint and assessing whether there are numerous incidents reported and whether the incidents are inappropriate in nature. If so, then the matter can proceed to the formal investigation. If the behavior complained of does not meet the definition of bullying, the matter should be recommended to be addressed in line with an alternative policy, for instance, the harassment or grievance procedure. Any such review and the recommendation to proceed with a formal investigation or other policy should be recorded in writing. Where it is deemed appropriate to progress the complaint to the formal stage, a trained investigator should be appointed to carry out an investigation. This can be a manager who has not previously been involved in handling the complaint. Alternatively, the process can be conducted by an independent third party, for instance, a HR consultant. Terms of reference governing the investigation should be issued to both parties, including confirmation that the investigation will be conducted in line with organizational anti-bullying policy, information about timelines, the importance of confidentiality, and an explanation that the purpose of the investigation is to establish, on the balance of probability, whether the person complained of has a case to answer. The formal process includes interviewing both parties and any relevant witnesses. Formal letters of invite should be provided to all participants, and the right to representation should be confirmed. Statements from all parties, including witnesses, should be recorded in writing. Those that made statements should be issued with a copy of them. Copies should also be provided to the employee who made the complaint and the person complained of. If possible, all parties involved should continue working as normal while the investigation is carried out. Should the investigation establish that on the balance of probabilities there is a case to answer, the matter should proceed to a disciplinary hearing. However, this hearing should only take place if the investigator's decision is not appealed by either party. Should an appeal be lodged, a separate manager should hear it and decide on the outcome. Let's look at the risk associated with non-compliance with relevant legislation and the code of practice. Should an employer fail in providing a workplace free from bullying or mitigating the effects of bullying, this could lead to low staff morale, negative consequences on employees' mental and physical health, loss of productivity, high employee turnover, and overall various employee relations issues. In addition, both the Workplace Relations Commission and the Health and Safety Authority could conduct workplace inspections. While the code is not legally binding, any failure to comply with its provision can be used as evidence in legal proceedings and will be taken into account, thus weakening employers' defense should an employment law, a personal injury, or a civil case be taken. So, to summarize, an employer who wishes to prevent bullying issues and if they arise to deal with them effectively should ensure they become proficient with the provisions of the code and definitions of bullying, implement a robust anti-bullying policy and procedures, create a strong culture where supervisors and managers lead by example, have their ear to the ground, and effectively address any early signs of conflict. Ensure everybody in the organization is fully aware of what inappropriate behavior looks like and what are the consequences of engaging in the same. Provide relevant training to all employees at induction stage, to contact persons before they are appointed, to managers who may act as a nominated person, to investigators or those that may hear appeals. Through open communication, encourage employees to speak to each other in a professional manner when the behavior they are subject to is unwelcome and offensive. Assist employees with early stage complaint resolution to protect the workplace relationships. Conduct investigations fairly and objectively without any delays. Where possible, provide employees with access to an employee assistance program and at all times support parties involved in any conflict and continually check in to ensure the conflict has been diffused. Further information and guidance on how to fulfill your employer obligations is available in the other video resources in this suite.